There we go. Nice. Okay. So, everybody, thank you so much for all of your patience while we're figuring it out. And we might still be figuring a little bit of it out, but I'm David Kinder, the admin of the Professional Life Agent Insurance Discussion Group. And I have with us here today Colleen Robinson. And Steve Martinez invited me to an estate planning basics workshop here in the Inland Empire. And I was privileged to be invited and to attend. I thought they gave a wonderful presentation, and I thought, you know what, this is something that our group needs. We need to cover estate planning basics. We need to cover certain questions that will come up, that often comes up in our group sometimes. And I thought Colleen did a great job presenting this at that time. And so let me give an official introduction. Colleen graduated at the turn of 2009 economic downside, which gave her limited options for employment. Unlike most of her colleagues, she was quickly hired by a family law firm. For the next 13 years, she appeared in courtrooms representing families all over Southern California, assisting families through divorce, custody, spousal and child support, domestic violence issues, and property division. A lot of things that we don't necessarily deal with as financial advisors. But her passion has always been empowering clients with education and tools so they can reach resolutions amongst themselves to save thousands of dollars and months, if not years, in the court system. She received extensive training to become a mediator in San Diego. With her expanding family, Colleen made the decision to step away from the courtroom to focus on her favorite aspect of being a lawyer, the relationships she builds with her clients. She's now practicing estate planning, working alongside clients in protecting their families and assets from court and conflict and creating their legacies. She engages with her clients to find out and plan for their goals and take the fear out of planning for the future. Her focus has been and always will be about the children. Her plans are tailored to ensure their safety and planning for their successful futures. Colleen lives in Fallbrook with her husband and 3 sons. Her hobbies include cooking, everything and all things. I don't even know how to say that. Peloton? Okay. I don't even know what that is. And chasing her kids, which of course at that age, that's what you do. So thank you very much, Colleen, for being here. Glad to have you. And by the way, as we go, I think people are going to have questions either in social media or here in the chat. Would you like me to do those in real time as we did before, or do you want to kind of save that till the end?
I would say let's save it to the end so we could get through the content, and
Okay.
then so then everybody hears the information, and I
Perfect.
think that would be the best.
Excellent. Well, Colleen, it's all yours now. And I didn't see Rebecca. Is she joining us today, or?
She's in a court right now. She was going to jump on as soon as she was off her court call. So hopefully she'll be joining us momentarily.
Okay, sounds great.
Thank you. Well, thank you so much for your patience in joining me this morning. My whole goal, as Dave so adequately stated, is education. And why I think this is so important for life insurance agents is that you understand how your products fit into an estate planning a plan, and how you can foresee certain problems, because I'm sure you also seen it all in patchwork or DIY types of plans that people put together. So my hope is that at the end of today, you'll have a better understanding on what is estate planning, why your clients should have one, and why you yourself should have one. So please, so if you have any questions, like Dave said, just keep them to the end. This might be me echoing, so I'm trying to see if that's the situation there. So this is my why, as Dave had mentioned, is my kids. And I came from a when I was in family law, very litigious, dealing with a lot of high conflict families. And so what I do now is utilizing, I'm going to try to figure out how to. So utilizing my experience in family law and dealing with high conflict families, and how can we prevent that in the future? And so by applying that to estate planning, my brain is warped from my years of litigation. And how do we backtrack in avoiding our families from becoming high litigious or high conflict families? Because I'll tell you, there's not much difference between family law and probate court. and that all the dirty laundry gets aired and relationships are destroyed. So I bring in my experience through litigation and how can we prevent that from happening when we're no longer here. So these are my three boys that keep me very, very busy. Me and my husband very, very busy. My oldest is 6. My youngest he's 2 today, actually. And then my middle child over there on the right-hand side, he just turned 5. So we are extremely busy. But the reason why I show this picture is that they remind me of why I have a plan in place, or why I have the particular plan that I do in place. It's great for me in terms of peace of mind, and it's a part of my financial plan as well, my estate plan. But it's knowing that if something should happen to me or my husband, that our kids are going to be taken care of the way that we'd want them to be taken care of. And so this picture always reminds me of that as well. So what I remind all of my clients, and I do these seminars quite frequently, is that one of the common misconceptions, or one of the common things that I hear quite frequently as to why people don't have a plan in place, is because it's too hard. It's too hard to put our brain in that weird space of what happens if, when we're gone or we're incapacitated. But what I remind everybody is that if you think of all of the things you do on a daily basis. So for example, I'll use myself. Like, I own a business, I'm an attorney, I service clients, but I'm also a mom to 3 kids. I'm the wife, I'm a friend, I'm a sister, I'm a daughter, and I am a chauffeur. I'm sometimes a part-time coach, I'm a snack coordinator, a chaos coordinator, a cook, you name it. I already said chauffeur. I'm a sling goldfish on full-time. So like all of these plates that we have spinning, and then it's rinse and repeat every single day. So I like to remind people that if you can do that, all the things you do in a single day, you can do an estate plan as well. And what my job is with our firm is that we hold your hand every step of the way to get it done and support our clients. So one of the acronyms I'm going to give you all, and you can apply this to any facet, whether you're in California, you're in another state, anytime you hear the word court, this acronym applies, which is CCD, and that means cost, conflict, and delay. So that's if we're talking about probate court, if we're talking about family or divorce court, if we're talking about traffic court or criminal court or civil court. I can't tell you how many times I've appeared all suited up, ready to go to trial. We get to trial and it gets continued. That's just the nature of the beast when it comes to court. And we're going to talk about what the conflict is. Conflict doesn't necessarily, especially in the realm of probate court, doesn't necessarily mean people fighting, because it may be an uncontested probate. It's the internal struggle of having to deal with a probate proceeding that it's not user friendly if you don't have an attorney. It's the stress that's associated with it. Am I filling this out right? What is the judge going to say to me? I don't know what I'm doing, and how long is this going to take? How much is this going to cost? It's that internal struggle. The cost, there is a lot of cost associated with probate. We're going to talk more specifically about that cost and what that looks like and how quickly all those adds up. Now, I just want to do a disclaimer. This applies my experience, and I'm licensed here in the state of California. This is specifically in California. But if you have any questions regarding any other state, don't fret. I am a part of a huge network of attorneys that are in 49 states. The one state I think that I don't know somebody in is in Vermont. And now every other state we've got an attorney. So if you have some state specific questions, I'd love to put you in contact with one of those. But there are very few states in the United States that's considered probate friendly. And then D is the delay. How long does this take? And the answer may surprise you. And we'll get to that as well. So the couple of the biggest fears that I hear quite regularly as roadblocks as to why people don't have a plan is, number one is somehow planning for it, like planning for my death or planning for my incapacity, will somehow manifest that to happening sooner. I have yet to see a study that actually, this isn't like Final Destination or anything along those lines, but I've yet to see a study that actually shows that if we plan for our death, somehow we're going to die sooner. I actually heard of a different statistic where from a financial planner, that by having a plan in place, it alleviates stress, and it could actually elongate your life. So I'm going to go with that one because I think it is more positive. That the process takes too long. I think that a lot of people just have mental fatigue just thinking about putting a plan in place, and then they just associate it takes too long. But what I do with my process is try to get it done as soon as possible. And through with myself and my staff, we are in constant contact with our clients. The hardest part is just making that initial phone call and making that initial appointment. The second biggest issue I hear, and this is all the time, is I'm not old enough or I'm not wealthy enough. So I was actually in a mom group, and someone told me, and someone told me that in their family, nobody has died before the age of 90. And I said, well, that sounds like great set of genetics, but things happen and that's not guaranteed. But if that's what you want to go by, that's fine as well. Another thing is that I'm not wealthy enough for a estate plan. I think this comes from media, the social media, or like movies, TV, that we hear about trust fund babies. Now, trust fund babies, that's a whole other category, or we think about like old money or something along those lines. But I hope by the end of today that you will all see that every adult should have some sort of estate plan documents, whether that is somebody who just turned 18 years old because now they're adults and they just need some incapacity planning, or even someone who has some accounts, or whatever phase or stage they are in their lives. Everybody needs something. And especially, we're going to be talking a lot about trusts today. Trusts are not for the wealthy. And I hope you'll be able to understand, are not just for the wealthy, I should say. And I hope you'll be able to understand that by the end of today as well. So estate planning, it's not about us. There is a portion that is about us because it brings a tremendous peace of mind, but it's about the people that our clients love, because they are going to be the ones to know whether you live up to your promise or they live up to their promise that I took care of that. Because I have met with a number of people that come in and they're shocked that they're going to wind up having to go to court, even though that their parents had a plan, but it was inadequate. So we'll talk about that as well. So I'm gonna talk about how much it usually costs, how long it takes, and how to get started as well today. So just so you have all the information as well. And I can tell you from the other attorneys in my network, we all operate pretty similarly. So this is how today's gonna work. I'm not gonna sit up here and just prattle on about like estate planning principles and elements, and I'm not a professor. But what I find that's most informative is to tell all of these examples. You're going to get the same amount of information as if we are in a traditional seminar where I'm just lecturing. But I'm going to tell it in a format of a story that I think you'll find more interesting and just as persuasive, because I think everybody can associate with a character. Either maybe you have a client who's done something like this, or you yourself have done something like this, or thought about doing something as one of these characters are. But this is what's happened. There's a car accident, and there's 3 different players involved. We have Tom, the truck driver. We have Mama Molly, and then we have the Doe family. And what happens is that Tom, the truck driver, his wife had passed away a couple of years ago, and he's on the road a lot. And he has a heart attack and dies and causes the collision. Then what happens here, these are the pictures of the three characters. He causes the collision with the Doe family, the people in the middle there. And then Mama Molly's all the way over to the right-hand side. She's just such a caring person that she renders aid. Somebody is on their phone, strikes her, and so she's rendered unconscious. They drive off. The Doe family, mom and dad, are unconscious as well in the accident. And they have 2 little kids that they're holding right there. So first, we're going to talk about Tom, the truck driver. So as I mentioned before, is that Tom, the truck driver, his wife died a couple years ago, and he has a 16-year-old daughter named Delilah. Very soon, you're going to notice that these names are not original. They all have alliteration for a reason. But so he has a daughter named Delilah, and she's 16. And it's been a rough couple years for Delilah because she's just lost her mom. She's in high school. And her dad's gone all the time. But what Tom did have is that Tom had a life insurance policy through his employer as $1 million. What he did do, though, is he named his wife as the beneficiary. He hasn't updated his beneficiary, so she's gone. And then the contingent beneficiary on the life insurance policy is his daughter, Delilah. So Delilah, absent just losing both of her parents, and that's tragic, she's thinking, oh my gosh, I'm going to be getting $1 million. My dad told me about this life insurance policy. He said I'd be taken care of if something should happen. I'm going to go live by the beach. I'm just going to finish high school online. I don't need to do anything. There's a problem with that, though. What Tom didn't realize is by doing this and having no plan for his daughter other than a life insurance policy, he's opened up two different forms of probate. One is a guardianship over the person and a guardianship over the estate. What does that mean? A minor child, somebody under the age of 18, cannot inherit directly. So those life insurance proceeds cannot be given to Delilah, as I'm sure a lot of you know. What would be required is that the life insurance company would say, you need to open up a guardianship of the estate first, get this special account set up, and then let us know and we'll distribute the check to that account. It is a process in establishing that. It does not happen overnight. There's a hearing involved. You have to give notice. It takes several months in order to get that. And then by not having a plan in terms of guardianship for who's taking care of Delilah, that needs to be established too, because a minor can't just live by herself with no oversight either. So that was certainly not the intention of Tom. And so then we've got Tammy Teacher. Tammy Teacher, see again the alliteration. Tammy Teacher, she is a very caring individual, and she's offered to take care of Delilah. She heard what happened. She's offered to take care of Delilah. So she contacts my office. What is required in order to do this? And what a lot of people don't realize is that because it's the court, there's a huge process involved. So in order for her to manage the money on behalf of Delilah, as well as even being her guardian, there's a criminal background check, a whole background check, and a financial background check that is conducted as well. And some people might think that's a little evasive, but the reason being is that the court needs some sort of guidelines in order to determine whether an individual is responsible enough to manage money on behalf of a minor child, or take care of this minor child too. It doesn't matter the intentions or how pure-hearted the individual is. There has to be some sort of benchmarks in place for the court to make that determination as what's in the best interest of the minor child. Hold on 1 second. So then we have Aunt Stacy. Sorry, my slide advanced a little faster than myself. So then we have Aunt Stacy. Aunt Stacy lives up. So I'm down here in Southern California. Aunt Stacy lives all the way. The accident happened down here. Delilah lives down here, by the way. Aunt Stacy lives all the way up in Sacramento. It might as well be Alaska, because she has no relationship with Delilah, hasn't seen her in over 10 years. And so Aunt Stacy pops out of the woodwork and says, I'm the blood relative. I should be not only taking care of Delilah, but I should also be managing my brother's money on her behalf. So now we've got a situation where we have Tammy Teacher, who actually knows Delilah and has been like a mentor to Delilah and watching over Delilah because she's been concerned with losing both of her parents and is noticing Delilah's behavior and becoming a little wayward. And then we have a complete stranger, but she's blood related. So what in this situation is a judge likely to do? Nominate or choose Aunt Stacy or Tammy Teacher? The answer is that we really don't know. And the reason for that is that the judges in the probate departments have wide discretion in making these decisions. One of the things that's so frustrating with the court system is that you could take the same case, you could take the same set of facts, even into the same courtroom on different days and get wildly drastic results, or go to different judges and get different results as well. So the answer is we really don't know who is the judge going to choose in this situation, especially with no information provided by the father as to what his wishes would have been. So we don't know. And by the way, I should have prefaced this, is that the probate department does a lot of different functions. One is that they deal with estate administration, so people who die with wills or without wills. They do conservatorships. That's adults that cannot make their decisions on their behalf due to some sort of mental deficiency, whether that's like Alzheimer's or Parkinson's or stroke or TBI, or that they have some sort of disability as well. And then they also do trust litigation and litigation regarding all of those topics. So it is a broad range of things that the probate department handles. So now we're back to the teenage millionaire situation. Is that what's going to happen with this money? And then when she turns 18 years old, Delilah, whatever's left in that account, in the guardianship account, or in the guardianship account of these, the guardianship over the estate, is given to her as soon as she turns 18 years old, because the court no longer has jurisdiction or the power to make any decisions over her now that she's an adult. So I don't know about you guys, but if you were inheriting, around $1 million when you were 18 years old, think about the decisions or how differently your life may have gone. Would you have gone to school? Would you have chosen the career that you in, or even met your spouse, or wherever your life circumstances would have been? I mean, even if I inherited $100,000, I don't know if I would have gone to school right away, or I could tell you my school experience would have been a lot different if I had that kind of money going into college. So let's see if we can fix Tom's story. So one is, why doesn't he just leave the money directly to Aunt Stacy? So the beneficiary designation would say, to my sister Aunt Stacy. And he goes and he has a conversation with Stacy like, hey, if anything should happen to me, this money's going to come to you, but I want you to utilize it for my daughter Delilah. And she says, oh, sure, no problem. Here is, if I could make this light up and flash, I would. Is that don't do this. And the reason for it is quite simple, is that money is legally Aunt Stacy's. Morally, that's a different scenario. So let's say that Aunt Stacy comes to my office and she says, I got $1 million from my brother from his life insurance policy. I'm the only beneficiary on it. And, I just lost my job. I'm 6 months behind in my mortgage. My husband is in the hospital. We have all these medical bills. Tell me, what can I utilize that money to save us financially? And I would tell her, legally, that money you can do whatever you want with. You don't have to spend a dime on your niece, even though you told your brother you would. Legally, it's yours to do with whatever you want with. Morally, that's a different situation, but legally, you can do whatever you want with it. So she's not obligated to use it on behalf of Delilah. So I'll leave it right there because I had a story that's appropriate for later on. Hold on. So the next scenario is, what if Tom signs a will and he states, to my daughter Delilah, all my assets, and if she's under the age of 18, then my sister shall manage the money. There is a big problem with this, is that a will is overridden by joint ownership and beneficiary designation. So what does that mean? So the life insurance policy that it states, to my sister Stacy, if he never changes that, the life insurance policy or the life insurance company, their marching orders is on that beneficiary designation, not what's included in his estate plan. So even if he had a will that said, if my daughter's under the age of 18, my sister is to manage it on her behalf, it doesn't matter. That money is still going to go directly to Aunt Stacy. This also applies to real property and how you own title. So how you own title with someone, for example, if it's in California, joint tenancy, there's a right of survivorship. So you might have a house that you own with, a relative or whatever, and you put in your trust or you put in your will that my portion is to go to my kids. You pass away. Guess what? That joint tenancy means it goes to the other owner automatically upon your death. It does not matter what's in your will or your trust. So I had it for a real life example in a family law case. I was involved at the very end. It was a very high contentious case. And in the divorce, the husband, who was our client, was awarded his life insurance policy. Shortly thereafter, he got sick, I believe, with cancer. And I can't remember if he had a will or a trust, and you're going to see why it doesn't matter. And it's why I don't remember that specific detail. And he nominated his brother to be the executor or the successor trustee, and he executes this in the hospital. He passes away. His brother calls the life insurance policy and says, my brother's passed away. Oh, and in his will or his trust, he says all of my assets to my adult sons. So once he passes away, he calls the life insurance policy to collect the proceeds, and the life insurance policy tells him that money's already been distributed. And he was shocked, and he said, to whom? And shockingly, they told him. I'm surprised that they did, to his ex-wife. His brother never updated his beneficiary designation and left it in the name of his ex-spouse while they were married, and never updated it after they got divorced. So that money went right to the ex-wife, and it did not go to his adult kids. So it didn't matter what was in his will or his trust, because that's not the marching orders in terms of distribution for the financial institutions. So that's for life insurance, IRAs, brokerage accounts, anything with that beneficiary designation. That's why it's so important that they have to be in coordination with an estate plan. So here, so if someone calls my office and states that someone's passed away, this is the order of analysis that I go through in terms of all the assets. One we look at is, how are they owned? Is there any joint ownership that may have a right of survivorship to it? Next, we look at beneficiary designations, because all of these things trump a plan. Once we get through the joint ownership and then the beneficiary designations, now anything left over, a will would control at this juncture. Or a trust, truly, it's the same way. So surprise number one is that the probate estate only includes things that did not pass to a surviving joint owner. So think of, like I mentioned before, joint tenancy, where there's an automatic right of survivorship, or your assets with a beneficiary designation associated with it. Here's another one, because this is a common misconception. A will goes through probate court. There is no ifs, ands, or buts about it. And the reason for that is that a judge is the only person that validates a will, saying, yes, this is the will of Joe Smith. And the judge is the only person who could approve of the distribution order. So because I hear this a lot. I have a will. I don't have to worry about it. Well, a will is a one-way ticket to probate. And the cheesiest line I'm going to say is that if there is a will, there is a probate. So then maybe you'll remember that when you hear these kinds of things from your clients. And by the way, even a will, it's the same process. It's the same time, the delay, and the cost. The only difference with a will versus not having anything at all is that you have some control over how you want your assets to be distributed. If you don't have a will in place, you don't have a plan in place, fear not. Your state has its own set of laws that distributes assets. So it's called intestacy laws when you die without a will. So in California, this is the probate process, and it works quite similarly in many other states as well. Is that first you've got somebody who's passed away here, and then you open up the estate, you file a petition to open the estate, and then we wait for a court order. And by the way, the same process if you die with a will or without a will. You wait for a court order in which someone's nominated either as, or appointed either as the executor, that's if there's a will, or special administrator, that's if there is no will. And this process, just waiting, because you don't have any access to any bank accounts, by the way. Powers of attorney extinguish upon death. A lot of people don't realize that either. So as of right here, waiting for this court order, there is no access to bank accounts unless there's a joint owner. But remember, if there's a joint owner listed on the account, upon the death of one of the owners, the other owner now owns that account. So let's say I use the example of my great aunt Sally. I don't have a great aunt Sally. I've never had a great aunt Sally, but I'm just using her in this example. She dies with a will, and she nominates me as the executor, and she's got a home that she's paid off, but it's got property taxes and utilities and things along those lines. And I go, you don't file a petition to open an estate immediately upon the death of great aunt Sally. You got to wait for the death certificate, which can take several weeks after somebody's passed away, because you also file that with the court. And then by the time you actually go to court, it's about 3 months after you file that petition. So there's maybe 4, 5, 6 months before you get a court order accessing her accounts. So I don't have the ability, let's say I don't have the ability to pay both my mortgage and her property taxes. A lot of homes in this waiting period are lost to the foreclosure process or nearly lost to the foreclosure process. And that's not necessarily considered an emergency for the court to jump the line and ahead of all the other cases that are pending the appointment of a court order for the executor or a special administrator. So finally, once we get that individual appointed, now they've got the court order to be able to go into bank accounts and start managing the assets, gathering, it's called marshaling or gathering the assets, figuring out what did Great Aunt Sally have. Hopefully it's all organized, but if not, now you got to go write letters and contact all the financial institutions to find out, does she have a bank account here, an IRA there, or whatever the situation is. It can be a wild goose chase. Then sell any real property if necessary, and there's a whole different process to selling property in probate. And then finally, we get to the order, the distribution, which you have to ask the court, may we please distribute the assets now? And the people that are paid first are attorneys and the executors. This is again in California, attorneys, executors. Next are creditors. So one of the things that's required, which I didn't mention here, is you have to put an ad in the newspaper. I'm talking about the physical newspaper. The legal industry is still a couple decades behind the rest of technology. We have to publish an ad in the legal classifieds that puts notice to creditors and to all potential heirs, or any weird family members that are fallen out of the loop, and now they get a chance to get in line in terms of distribution. So if, for example, I had a probate case, like American Express filed their creditors claims, an optometrist filed their creditors claim, all like car loans, because a lot of the larger institutions, like financial institutions, pay people to go through the legal classifieds to see if there's money that's out there that may be owed to them. So they put their spot in line, and they're paid before the beneficiaries are. The last on the totem pole in terms of payout are beneficiaries. And if anybody's over the age of 18, they just get a lump sum check. So that's what I was also mentioning, like, think about yourself. If you were 18 years old and you're inheriting a decent size, even if it was $50,000, how would that change your life at 18 years old? What kind of brilliant plans would you execute at 18? This entire process in California takes approximately 1 to 2 years, and that's not a complicated estate. So in San Diego County, as well as Riverside County, which is the neighboring county here, there's only 4 probate judges. And I mentioned that those 4 probate judges are doing a lot of different things. So 1, it's an extremely compacted calendar. And then 2, there's a required time period in which an estate has to remain open, and that's 4 months. The reason for that isn't to benefit the beneficiaries, it's to allow creditors to file their creditors' claims. So this process is not beneficiary friendly at all. It favors the creditors. The cost of probate is approximately, this is a conservative number, 5% the value of the estate. You might be thinking, wow, 5%, that doesn't sound so bad. Well, let me use some real numbers. So in Riverside County, this is a couple months ago, the average home value was $600,000. So just applying, so let's say my great Aunt Sally, that's all she had was her $600,000 house. The cost of probate is $30,000. So it adds up really, really quickly. And if you, like down here in San Diego, the average home value is about $900,000. So now it's $45,000 and 1 to 2 years before assets are distributed to the beneficiary. So it takes quite a long time to get there, to get through and to get the estate finalized. So here's scenario number 3. Tom gets a living trust. How does that work out? So it's the same language. It says to my daughter Delilah, all my assets. And if she's under the age of 18, my sister Stacy to manage them on her behalf. But before I get into that scenario, let's talk about what is a trust. So a trust is a will substitute, meaning that when it's properly funded and it's proper and it's updated regularly, it will avoid probate court. At its fundamental definition, it's a legal entity that you create while you're living that manages your assets. It owns your assets for you. And then once you pass away, it manages and distributes assets to your designated beneficiaries. So I mentioned this, as long as it's properly funded and updated, it avoids probate court. So what does that mean, funded, and what does it mean by updated? So I'll talk about updated. One is that in the last couple of weeks, I have been reviewing a lot of pre-existing estate plans. Literally, I had a couple bring them in and I had dust on the top of it. That is extremely outdated. It was over 10 years old, outdated. They hadn't looked at it since they executed it. And the problem with that is that their assets have changed and the assets weren't where they're supposed to be, or their schedule hadn't been updated, a schedule of their assets. So if something had happened to them, their family members would have no idea what the type of assets they would have had or what they were going to need to do. Properly funded means that the trust needs to own property. So for example, like real property, we do a new deed. So the trust needs to have our own property in order for it to be validated, or to be valid, I should say. So let's take a look at this in a little bit deeper detail at how this works. So going back to the 3-bucket analogy, is one is like if we're dumping all of the assets over these 3 buckets, this would be a successful or a fully functioning avoiding probate trust, is that one is that all the assets correlate with the trust. 2 is that those beneficiary designations are updated as well to be in coordination with the trust. And then once all of that happens, there will be no court and it would remain confidential. So what do I mean by remain confidential is that with a will, you have to, it's called depositing it and the probate court, meaning you take the will and you literally bring it to the probate court. They can't file stamp it because now they're altering the document, but it's there for public consumption. It's there for public access. So I have, for example, the wills of Anna Nicole Smith. She's making a comeback now on Netflix. I have Babe Ruth's, Jackie Kennedy Onassis. And not because I have some like inside connection with people in Hollywood or whatever, but because they're available for anybody. Like they're public documents. So and the issue with that is when you file the petition, along with depositing that will, all the beneficiaries are identified, including their contact information, as well as what each beneficiary may be receiving in terms of an inheritance. And they start getting contacted by all kinds of people as well. So when this is done properly, there's no court and it's confidential. Like to give you a bad example of what happens if it's not, the beneficiary designations aren't updated. So I have a client whose parents passed away in short order from one another, and they had a trust, and her stepdad was like, don't worry, we took care of it. You have nothing to worry about if something happens to us. They had their retirement policies. They had over $1 million in retirement, and they didn't update their beneficiary designation. So they left it to each other and then nothing else. And so what that did is once they passed away, now my client, who was the successor trustee, had to go to court. It wasn't a full probate process. It's called the Headstead petition here in California, is to ask for an asset to be put into the name of the trust or transferred into the name of the trust. But it was still something she wasn't expecting to have to do. And she has a family member who causes a lot of difficulty, and I saw that as an open opportunity to try to contest the trust. It cost her $40,000 to do all of that. And it was a lot of delay as well. And she had to use her own credit cards because she didn't have any other access to money to pay these attorney's fees until they got access to these retirement accounts. So had her parents just put their spouses, each other, as a primary beneficiary and their trust as a contingent beneficiary, it would have saved family strife and over $40,000 in attorney's fees. So this little picture of this creepy kid and his little red wagon. So think of like those Radio Flyer red wagons. My kids have like the little Tykes red wagon, so it's still applicable. The wagon is your trust, and you as the trustor, the creator of the trust, you're pulling their little red wagon, and that red wagon is supposed to have all of your most prized possessions in there. And you'll see in this picture is that the house and the bank accounts are outside of the trust. So if you pass away, the only person who can put those assets back into the red wagon is a judge. And that's the example I just gave with those retirement accounts. So in this example here, now you'll see everything's tucked in nice and tight. Your trust already has who's going to be pulling that red wagon after you pass away. So that doesn't matter. And now we would avoid probate case or probate court in this situation. So a review of assets has to be a part of an estate planning conversation. I don't know how attorneys can do it otherwise. And I think it's a disservice to clients when I just don't understand how you can do it. So when I review or set up trusts for clients, or we're talking about setting up a trust, we look at everything under the hood, talking about the different types of assets and how they would all work going through probate and what they want to do differently. And a document alone is not enough. So like I gave with the example of the gentleman who had signed the deathbed will or trust, without going a step further and making sure all of his assets were in coordination with this plan, it didn't matter. That's why I don't remember if it's a will or trust. It doesn't matter what's in your estate planning document if it's truly not in coordination with your other assets. So that's the longest part of the presentation. So thanks for hanging in with me because it covers so many different situations. So let's talk about the Doe family. Their situation is a little bit different because we've got minor children that are involved here. So as I mentioned, mom and dad, John and Jane, really original names, they're rushed off to the hospital. But what happens to the kids in this situation? They're in the car. Thankfully, they're okay. Who's going to take care of these children? So Jane has a brother, Bob, who lives a couple hours away, and they're trying to get a hold of Bob. And he's not answering because he works the night shift and his phone is off during the day because he's sleeping. So what is law enforcement likely to do in this situation? If Jane and John could speak, they would say, please let our kids go. And this is the woman that's pictured here with Nanny Nancy. Again, see original name. Nanny Nancy. She knows our kids. They love her. She knows their schedules. They know that Tommy's got Boy Scouts on Wednesday and Susie's got ballet on, or not Susie. The daughter's got ballet on Thursdays, and that, you know, little Tommy likes all of the crust cut off of his sandwiches and the medication that they take, and so everything would be kept consistent. But without a plan or even temporary guardianship, which we're going to talk about, law enforcement has no way of knowing any of that. And they have very limited options on what to do with minor children in case of emergency like this. So what I do with my clients is create their own team of first responders. So what does that mean? That means is that we're not just nominating guardians as to who's going to raise children until they turn 18 years old, is who's going to be available to take care of kids in an emergency type situation. So in some people, those are not the same people. Like in my situation, I'm just trying to find my mouse. My situation, my long-term guardians don't even live in the state. They live out of state. So my brother, for example, he lives in Phoenix, and from here to San Diego, it's a really short flight. But like I mentioned before, my kids have to go somewhere. And so if even if he got on the plane, it takes like 55 minutes to get from Phoenix. It's still, he's got to, drive to the airport, go through security, get here, get a car, and get up to my kids. That could be several hours. As I mentioned, like law enforcement have very limited options if there's minor children in an emergency situation. In California, they would be released to CPS and placed in foster care. So what I do is create an emergency plan. Who is within like 30 minutes of your kids that could take care of them temporarily until maybe the long-term guardians come into play. So until my brother could get here. So I've got my in-laws and my parents as our temporary guardians. They are not fit to re-raise kids. They're in their 70s and they don't want that job. They've been and I appreciate that. And I wouldn't want, they're not unable to. I have little kids. Like my parents may not be around when they graduate from high school, or just being able to keep up with them. They're exhausted after an hour that we descend upon their house. So guardianship is equally about what happens in an emergency as who's going to raise kids in the long term. So we're covering all bases. So Jane's injuries linger. So she's still, John makes a full recovery, but Jane's still in a coma. Her parents fly in, understandably so. They're very worried about their daughter. And they're having some disagreements over her care. And they also do not have any sort of plan in place either. So this is John, that's her husband. And now we've got conflict between the family as who is going to be making the decisions on Jane's care. So you might be surprised, well, it should be the husband, but the law does not presume that the spouse is the most fit person to make the medical decisions. So the doctor in this situation is like, you know what? You guys can't figure it out. I need a court order. So I know exactly who I'm talking to make these decisions for Jane's health care. So now we've got, it's called the conservatorship proceeding, as I mentioned before, is Jane's unable to make her own medical decisions. So now we need an individual to make, we need somebody appointed with the court authority that the hospital recognize and take those orders from. So without an estate plan or healthcare directive, who can make medical decisions on behalf of Jane? The answer is the court at this point. So now John's got all these stacking medical bills. And I forgot to mention before is that Jane's got a separate bank account that she inherited $100,000 from her aunt a while ago. So John knows about the account, like she's been very open about it. And he's like, okay, great. I'm going to go down to the bank. I'm going to get money out of that account to pay off some of these medical bills. So to alleviate some of this pressure. And so he goes down to the bank and he's like, I would like, access to account number, blah, 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 and withdraw $5,000. The bank says, I'm sorry, you're not listed on the account. You have no access to it. And he's like, but I'm her spouse. It's a community property state. I should have access to it. And they say, sorry. So this is another situation where title, how she owns this account matters. So now we're in probate court for two different reasons. One is who can make financial decisions on behalf of Jane and who's going to make her healthcare decisions. So Jane's mom also thinks that she should make the healthcare decisions the financial decisions, because that money in that account actually it was her sister's money. And she's like, it was my sister who passed away. I think John is fiscally irresponsible and I should be the one in charge of those assets. So now we've got John or Jane's parents, and it's the same situation. Who is the court likely to choose? And the answer is we don't know. So and we've got a feuding family. How could Jane fix this and prevent this from happening? There's three different ways. One is to have a healthcare directive and a HIPAA authorization. The healthcare directive specifically states who's going to be in charge of making the medical decisions. And then the HIPAA authorization also has access to private healthcare information. I also call HIPAA authorization family diplomacy. And what I mean by that, I'm going to share my example, is that on my healthcare directive, my mom is not listed as an agent to make my healthcare decisions. And it's not because I don't love my mother or I'm not close with my mom or I don't trust my mom or anything along those lines. Is that I know that those decisions would be too hard for her to make. But she's listed on my HIPAA authorization. So she's at least able to get access and being able to talk to a doctor. It's just that she doesn't have the ability to make my healthcare decisions. So that's step number one. Step number 1 and 2. The last thing is to have a financial power of attorney. So this is a complete incapacity package. And like I mentioned, every adult over the age of 18 should at least have these trifecta of documents. I'm saying that it's horse racing season here in Del Mar. So that trifecta of those three documents. A financial power of attorney is that you're nominating somebody to act in your place while you're incapacitated to make business and financial decisions on your behalf. So with that would prevent altogether a conservatorship proceeding. So as I mentioned before, the only person other than yourself who can make your decisions is a probate judge if you do not have any of these documents in place and you're incapacitated. And it's a process. Again, we're talking about the court. It's a process to get a conservatorship involved or implemented, because they're not favored by the court, because you're taking somebody's civil liberties away. Being able to make these decisions are big decisions, are medical decisions, and are financial decisions. So it's not something the court takes lightly. And so it's a process involved, and it can take a very long time, even when it's readily apparent that an individual clearly lacks capacity. Like, here they are, here's the video, they're in the hospital, here's the doctor, they're saying they're incapacitated. That's like hurdle number 1. It's getting through all the rest of the requirements for the conservatorship as well. So it's not an easy process. So let's go to Mama Molly. As I mentioned before, she's the pure heart. Like, that bystander, that innocent bystander that pulls over to the side of the road trying to run her aid, and she's hit by the car, and she too is unconscious and taken to the hospital. But what Mama Molly has in place is she has a revocable living trust, along with guardianship nominations, temporary and permanent, and all the financial powers of attorney, you name it, she's got it. So while she's in the hospital, her husband is able to focus on her care and her long-term care, because she is requiring a lot of rehab, and maybe it's outside of the home. But because they've got their guardianship nominations in place, grandma and grandpa or whomever, the temporary guardians are able to take care of the kids, take them to school, take them to the doctors, take them to the therapist, you name it, because that's also a part of what I call the kids protection plan, is giving medical authorization, medical health directives or powers of attorney on behalf of our minor kids, so that our temporary guardians can take them to the doctor absent an emergency. Also in a trust, there's incapacity planning. So if necessary, in Mama Molly's plan is that their successor trustee could step in and manage their finances until she's fully recovered, which, by the way, she does. And then all of the things that they had in place just kind of go back to the background and wait again until they're needed. So the temporary guardians go to the sidelines, that successor trustee steps away again, and until they're needed or once they both pass away. So this is what she has in place. And what she does regularly is that she's got a trust-based estate plan that's reviewed in at least every 3 years, power of attorney, healthcare directive, and the kids protection plan. So here is a basic review of what everything we just covered, which is a lot. Is that a will goes through probate. When a trust is properly funded, it avoids probate process altogether. The review of assets is a critical component. It's absolute part of an estate planning conversation, looking at title and beneficiary designations. And if there's minor children, short-term and long-term guardians are absolutely essential, because we just don't know what's likely to happen. So a lot of people ask, like, do I need a lawyer? I mean, there's LegalZoom and all kinds of things out there. Do I really need a lawyer? I have access, or I can give you guys the link to the kids protection plan documents. You can at least get your temporary, or you can provide that to your clients that, though it's California based, getting some of these nominations in place. I can give you the link to do that, to provide that to your clients for free. But in terms of, one, making sure you have a plan that'll actually work once you pass away, because again, I review a lot of estate plans recently. It's like been a wave of pre-existing estate plans, and that a lot of clients there's not a complete schedule of their assets. It hasn't been updated in a really long time. They don't understand how their own plan works. They weren't given adequate instructions on how to fund their plan, because the attorney was just so focused on churning documents. There's no educational component of, now you've got this trust. Now the next step is to do the following to make sure your family wouldn't go to probate court and that these documents are rendered useless. So if that is a concern for your clients, it certainly would benefit working for an attorney. You get what you pay for. And I've seen a lot of these do-it-yourself plans. And when you don't understand the documents, it can cause a lot of problems, because again, it's not about us. It's about the people that we love and who would have to clean up our messes when we're gone. So what I do, which is different than a lot of other attorneys out there, is that I do everything on a flat fee. I do not charge by the hour. It's a terrible way to live. Same with my partner. Like, we don't charge by the hour for our estate plans. So like, my life was dictated by the 10th of the minute. And what I've noticed is that clients don't like it.
Something just happened there. I think the cell phone cut out.
Unmute myself. I don't know if you guys can hear me.
I can hear you.
Okay, let me just get right back on here. Stop my screen share and get my audio back.
Yeah, Steve, I'm sure I'm the echo. I'm sorry.
So I'm just, while my phone is uploading here back onto my audio, I'll just keep talking since you guys can hear me, and reshare my screen. So I don't charge by the hour because it's a terrible way to live. And what I've noticed is that my clients, they get surprise bills. They don't like, they go out and they try to do things on their own and they make a bigger mess. I'm sure you've all seen that as well. And so I eliminate that barrier of communication because clients didn't want to contact me and they don't want to contact me. They don't want to email me. And by the time that they eventually do, it's going to cost them even more to fix the problem that they've tried to create or they try to do on their own. So we just don't do that. Plus, I want to talk to my clients because I have great clients, and when they let me know what's going on with their lives, then the way that my warped brain works is that then I can make sure that their estate plan is in coordination with whatever's going on with their lives. One is ensuring that the assets are owned in the right way in coordination with their estate plans, is that we do all individualized family needs and making sure that everything is whatever the needs are of my clients, whether it's their kids, their family members, or they different scenarios. They have a blended family. All their considerations are taken into account with their needs. And then what I also do, which is unique, is that we capture the non-liquid assets to our clients. And what that means is that I interview all of my clients. It's completely discretionary, but it's one of my favorite things that I do. It has nothing to do with the law. And we go through like family stories, their value systems, how they met their spouse, where they grew up, who their parents, their grandparents, their cultural values, things that are important to them. And then every 3 years when we review everything, we add on to that legacy library. So when they do pass away, they're passing along so much more than just money, because I think money is you're able to re-earn money, you're able to make money, but you cannot, as of right now with technology, we can't recreate the sound of someone's voice telling these stories that are most important to them. So it's a beautiful process, and I know that their family members are just going to really cherish these videos. So usually I get this a lot, like what happens, what's the cost of creating an estate plan. It just depends. Our fees, for example, go anywhere between 2,000 up to 8,000, where everybody is somewhere usually around right in the middle. And but it's knowing that your plan is going to work, and that's just a one-time fee, and then we're just maintaining that trust when we meet every 3 years, which is also complimentary. So what I offer for the attendees, if you're here in California with Zoom, and I promise my Zoom usually works without failure, is that I offer. Okay, let's see. That's echoing. Here, I'm gonna unmute myself. So we offer. Sorry, it's echoing. Our meetings are, it's a family wealth planning session. It's usually $750 because it's a 2-hour meeting. We go through a lot, and we actually design your plan, or that you get a full, you know exactly what you need to do at the end of those 2 hours.
We've got massive echo because I think you got two mics going at the same time.
Yeah, let me see if I can fix it.
That one's not my fault, Steve. Okay.
Yeah, it's totally me. I'm trying to figure it out.
I think you're good there.
Okay.
Yeah, we're good there.
Okay. All right. Yay, technology. So you book your family wealth planning session with us. We'll take off $250 for any plan that you wind up choosing. So it's $1,000 saving right there. And I can provide my contact information. my email address, my phone number, or if that you're out of state and you're looking for more information or wanted to talk to a local estate planning attorney that practices like I do, I would love to make that connection for you as well. So please do not hesitate in doing that. So at this point, I'd love to hear any questions that any of you may have.
Perfect. By the way, I've been scrolling on our streaming. We've been scrolling your firm's website, protectyourfamily.law. So that's been
Yes.
scrolling all the way across the entire time. So that's an easy way to see, Colleen's information, Rebecca's information, and you could reach out obviously through their site. They're very responsive. Star is their CSR, CSM, their client service
Yes.
director. So she does a great job in reaching back out and coordinating things. A couple of things that you mentioned in the live presentation that we didn't quite touch on here, and part of it is planning for children with special needs. And I really like your answer and how you guys work on that. If you would elaborate, I'd like to share that.
Well, so through my experience in family law is I've dealt with I've had the pleasure of working with a lot of special needs families. And there is so much more that needs to be put in place for those families. And um, one is just what is their level of care? What happens when the families, like mom and dad, are no longer there? How do we set up so they have the most consistent living situation and lifestyle? Because a lot of those children, everything is based upon consistency, and a disruption in that consistency can just be devastating. So, I've gone through a lot of training with special needs families on how to plan for special needs families, but it's just understanding what those needs are. What I include in all of my estate plans is that even if we don't have a situation where, I should back up. One of the issues that you have to understand with special needs families are all of the benefits that that child or that adult is receiving, and that if they inherit assets directly, they could lose those benefits. So, for example, if you have a child who has autism, like severe autism, they cannot work. You do not have a plan in place set up on how to deal with their federal and state benefits, they could be kicked off or terminated from those benefits. So it's huge. It's a huge planning consideration. And what I include in all of my plans is just a what if. Because I had a client in her 30s slip and fall in her bathroom and suffer from a traumatic brain injury, and she could no longer work. So it's having the provisions in place that if this were to happen, if any of my beneficiaries should need state or federal benefits, that it's got to be set up in a certain way. It's called a special needs or supplemental needs trust that allows the beneficiary still to utilize and benefit from the assets that you leave behind while maintaining their eligibility in those programs. So it's just understanding how all of those pieces play together, and also educating your successor trustees, or having an appropriate successor trustee that understands the benefits of the beneficiary. So sometimes that may not be a family member. You may need to have a private fiduciary be appointed who understands these state and federal programs and what their requirements are, etc.
Perfect. Thank you.
Mhm.
Well, I also want to go back because near the beginning, you talked about the minor child who would normally receive such life insurance benefits, and I've been working on a case, and the let's just say the legal counsel that I had talked to at the time said that if that was the case, if the agent set up a minor to be the beneficiary, and someone else receives those funds, the legal counsel that I got was that the agent who set that up could be held liable by the intended beneficiary. So I
Wow.
want that out there, and that they can come after you later. And I don't know about any statute of limitations or anything like that, but that's something that was brought up in this particular case. And by the way, the person I'm referring to, he wrote the book on survivorship life insurance published by the bar. So I'm not talking about someone who doesn't know. This guy knows. So I wanted to let that be out there. Now, there's a great question that's in here that Amanda Lee has asked. And by the way, currently, but the same person just told me a couple of weeks ago that there's only been about 1,000 estate tax returns filed. So it's been a smaller and smaller issue. But she brings up a great point. She asks, do you do estate tax planning for high net worth clients with assets more than 30 million plus? They worry
Right.
about the exemption that will go down to 5 million in 2025, and they want to know any creative legal ways to reduce their estate tax.
So that's a great question. So right now is the federal. I'm speaking from California. Every time I say it, I'm just shocked. Is that there's no estate tax because it's my theory we're taxed on everything else. But so there's no estate tax in California. It's not the same with every state. Federally, the federal estate tax threshold right now is really high. So for a married couple, it's $25 million. Anything above $25 million is taxed at a rate of 46%. That's huge. So under Trump's administration, whether you liked him or you hated him or still hate him or whatever, doesn't matter. He swung that exemption so high. And now that sunsets, as Amanda said, in 2025, and we don't know where it's going to land. There's speculation, maybe it's $4 million per person or $8 million for a married couple. So with clients with high assets, there are lots of different creative ways. And especially if you have clients with over $30 million, I team up with financial planners they specialize in real creative ways to avoid estate taxes in this situation. So the answer is yes. And there's a lot of different tools that are available in order to minimize or completely reduce that estate tax burden.
And I would say, as financial planners and insurance agents, don't be afraid to team up with anybody. I'd rather team up, split a commission case to get the job done right, than not team up and really screw it up. So always be willing to coordinate and collaborate. By the way, you'll never know what you'll learn. And of course, they want more business coming from you, because if you know one person like that, you probably know more. And you can always work collaboratively in that way.
Oh, absolutely.
Absolutely. And so one of the things we also talked about before was make sure you've got the documentation for your children who've turned 18. Got to make sure that you've got those documents in place, because once children turn 18, not just the special needs, but all of your children, to make sure that, hey, they're away at college, they get hurt in something, make sure that you can be listed to be someone to help make medical decisions and financial decisions and things like that. So we had talked about that before too. And you already brought up in your slides, do I need an attorney? Because we have often the question comes up in our group. Some people do their own estate planning documentation and they're not acting as an attorney. I want to clarify that they're not doing the unauthorized practice of law, but they have these pre-done programs, estate document preparation services.
Right.
And I just think that it's so much better to, you might be paying twice as much, use an attorney. I believe that's my opinion, and it really should be yours. Okay.
Well, it's certainly my opinion, but I'm biased. But you really do. What I've noticed is you get what you pay for. And if you're looking to save money for yourself now, that could cost your family thousands, $10,000 and years in court because you didn't want to pay an attorney to do it correctly the first time.
Absolutely. And I'm a big believer in, I think they call it DERF, do it right the first time. I'm a huge believer in that. So any other questions that are coming through? I don't see any in the stream here in the Zoom room. Armando, I'll message you privately on that one. Anyway, other than that, I can't think of anything else right now. You really gave a great presentation. You covered a lot of bases that we need to just have at least a basic knowledge of, so we can inspire and instigate those conversations and bring them to our attorneys of choice. Obviously, Colleen and Rebecca. Rebecca, I did see her pop on and then she popped off. I don't know what happened there. Armando asked, if you do your own estate legal work, you may have a fool for a client. Fair enough. Okay. And some people might think that about their own financial planning too. Sometimes it's good to have an outside financial planner for your own things, even though you're in financial planning. I throw that out there. I know some high-level people in financial planning who hire other people to help them just to have the objectivity, so they're not so close to making those decisions. They can have greater objectivity in making financial planning decisions. So, anyway, I really want to thank you, Colleen, for coming on board. This was great, as best as we can for the technology and everything going on. We'll make this work.
Thank you so much for your patience. I'm so sorry this was so choppy this way, but we made it work.
We made it work. And Steve, thank you for making the introduction so we can make this happen. It's really appreciated. And this is something that we needed for our group. We wanted everybody to get just an estate planning refresher. And of course, Colleen, if you'll email me the link for the national firm, or they obviously can email you, but I can put that into some links and make sure that people can reach out to whoever's local to them. So we go from there. Thank you all so very much. We'll catch you next time. I've got a great special guest for August. You guys are going to love this. So get you all next time. Thank you so much.
Thank you.